just a minute left. So we'll give everybody one more minute to join here, but welcome to those of you that have joined us so far. So Marsha, I can see your home page, not our slides. There we go. Now I can see the slides. All right, well, let's go ahead and get started so that we're starting right on time here today. My name is Mandie Reed, and I'd like to start by just welcoming you to our third session of the estate and legacy planning for parents and grandparents raising minor grandchildren. And today we're going to talk about revocable and testamentary trusts. So like I said, my name is Mandie, and I'm the Montana State University Extension Agent in Wheatland County. And I'm happy to be co-hosting this series with Marsha Goetting, who is our Extension Family Economics Specialist at Montana State University in the Department of Agriculture and Agriculture Economics. Excuse me, I got a little nervous and tongue-tied. So I also would like to introduce our special panel guests today. So we are really excited to be joined by Heidi Lester, who is running Montana State University's Extension's Kinship program, and our Ag and 4-H Extension agent. She's actually the only agent in Glacier County, and that is Kari Lewis. So they're going to be our panelists later on and answer any questions that you guys have for them. So we'd like to welcome the 64 Montanans that we have joining us on our webinar today. And I'm just curious, how many of you have joined, let's see, how many of you have joined us before? So if you've joined us before, if you could just jump down and put a little note in the chat box, that would be excellent. So then we know how many people are coming back. We'd also like to welcome our the 9 participants who have joined us from other states. So welcome, and we're happy that you were able to join us as well. So we'll go ahead and start out with Marsha and Mandie's top 3 participant engagement tools. So we want to make sure that this presentation is exciting and engaging and interactive so that we're going to learn more from each other and give all of you a chance to interact and ask, and then we'll learn from you also. So the first one is the chat room, and I've already asked you to use that, but it's a way for us to get your responses to questions and then you to ask us questions. So I would really encourage you to use that to drop something in our chat room, drop your questions in the chat room. So also, we are going to remain on WebEx for another 15 minutes after the webinar is over to answer your questions. And the way you'll get those questions to us is using that chat room. And then the panelists and Marsha and myself will be there. The other engagement tool that we're going to use is our poll questions. And so we have specific answers, and then we need you to just look at the right-hand side of your screen and answer those questions. So we're going to try one right now. Our first question is, as a result of last week's webinar, what action, if any, did you take? So did you read the mock guides about wills? Did you make an appointment with an attorney to have a will written? Did you review how your property is titled? Did you contact a legal developer program in Helena about having a will written? Did you use the will forms at the legal developer site, or did you do something else? And if you did something else, if you could put that in the chat room, that would be awesome. So we really want to encourage everybody to use these engagement tools. It's more interactive for us, and also I think more fun for you also. All right. So we'll just give people a minute. Nice, thank you. It looks like several people took some action, so thank you for doing that and engaging also in the poll questions. So Marsha, would you please explain our third engagement tool?
Okie dokie. I'm gonna get there. Okay. Third engagement tool. Well, if you can see behind me, you see that I'm a little bit nuts about wildflowers. And I've been using over the past couple of years wildflower names as a way to help you remember some of the key points and also maybe try to be more clever about some of the topics. I know estate planning sometimes can be a little depressing. I mean, we're talking about the potential of us dying, and yeah, we know it's going to happen someday, but we prefer it to be later rather than sooner. So we're going to use these wildflower names. And here's one that I just love. It's called a steer's head. And I'm sure if you take a look at that, you can see the ears of our steer, the eyes, very, very cute, but tiny, tiny little flower that you can find in Yellowstone National Park. So what I want to steer you, and Mandie also, is to consider the benefits of a revocable living trust that you can use to protect your children or your grandchildren. We also want you to consider the benefits of a testamentary trust. We've just come out with a new mock guide by that title, and you can see today we'll show you how you can use that also to protect your children or grandchildren. Now, what I'm going to do is use a sugar bowl, that's the name of this plant, to represent a place where money goes. And I must confess, when I was a kid, my mom had a sugar bowl up at the top of the kitchen cabinet. And I saw her one day putting some money in that sugar bowl. And of course, I was very interested in it. So of course, when mom wasn't looking, I'm climbing on the counter and I'm getting up and I'm looking in the sugar bowl. Ooh, a wad of money. And of course, I didn't even think about taking it, but I wondered, what is mom saving for? And she puts it up there. Would you believe a vacuum sweeper? So as a kid, I was really disappointed that you use that much money to buy a vacuum sweeper. Well, moving along, we're also going to play some estate planning trivia today. And those of you that have joined in the past know that I ask a question. And the question today is, what is the dollar amount that you can give annually and not have to pay a gift tax on it? And so what you do is you write that answer in the chat room. And those individuals, I used to say the first person that gets it right wins a wildflower card. And I found the system sometimes has 4 or 5 people all checking it at the same time with the right answer. So that means all 4 or 5 get a wildflower card. So hopefully those people that participated last week have theirs. I had some that I was doing late because the list got lost in all my paperwork. So that's the one, and I hope we'll have a winner today. So let's take a look at really what a trust is. It is a legal entity. Once you form a trust, then that trust holds title to the property that you put into the trust for the benefit of the beneficiaries. And those beneficiaries then can be your children and grandchildren. And there's a whole bunch of things to learn about trusts and the terminology. There's a settlor, there's trustee, there's successor trustee, beneficiary, I think we know, and then the trust agreement. So I thought I'd quickly go through these so that we're all on the same boat knowing what we're talking about. So you can have a fancy name for your trust, but many people that establish a revocable trust just use their names, and then they use themselves as the trustees. So what we've got here is James and A. Simon and Lois R. Simon, and they are trustees of the Simon Family Trust that was established on March 20th in the year 2021. Now, when you have a revocable trust, it means first you got to change the titles of items that you want to put into the trust name. So for example, we've got Lois and her husband may have their names already on the checking account, but that has to be changed to their names as the trustees for the Simon Trust. Now, what kinds of things can you place in your trust? Land, your home, your checking account, your certificates of deposit. Maybe you've got stocks, bonds, mutual funds. All of those, if you want them to be controlled by the trust, have to be in the name. of that trust. Now, I remember several years ago, we had a disbarred attorney from North Dakota that was coming over and talking to some of our ranchers in the eastern part of the state. And he was selling them, get this, a revocable trust papers for only $1,800. And the reason I knew he was out there doing that is then I was getting calls from people saying, okay, we've got these papers. Now what do we do? So we got to watch sometimes those characters that give us a so-called good deal that it may not be. So again, put this in the brain. The trust document only controls the items that are in the trust's name. If you left something out of the trust, then it's not the trust that's going to control what happens to that CD. Okay, we got that in the brain. So Mandie, why don't you tell us some of the other terms such as settler, which I thought was a homesteader.
All
Moving
right,
along.
Marsha. All right. In this case, a settler is a person who puts the assets into the trust. So this is the person who's putting the assets into the sugar bowl, if you want to think about it this way. And that's who that is. A trustee is the person who's given control of the property in the trust, and they are legally obligated to administer the trust as it was specified in the trust agreement. So they become the fiduciary. And so I had to ask Marsha, what is that? And so they're obligated to do, their obligation is to do what's best for the trust, what is described by the settler, and they really need to do what the agreement says. So a trust.
Yeah, in other words, they're not supposed to use that money for themselves. If I name Mandie as the trustee for a trust for me, I do not expect her to use that money to go off and go to a rodeo in Texas or Denver or someplace.
Doesn't that also mean, Marsha, that I can't decide how to use that money? I can only use it as you specified.
Right. You're supposed to follow the directions in the trust agreement. And pretty soon we're going to look at some of those agreements and see how, well, unclear they might be.
Excellent. So their job, a trustee's job, is really to write the checks for things that were specified. So this might be the living expenses of beneficiaries' education costs or other costs that are listed in the trust agreement. So one way that I was thinking about this is my children were fortunate enough to be awarded a scholarship that paid for their education expenses. And so it was a family trust that's located in our area. And so then the college will send them their tuition expenses and then they pay the college. So the people who are in charge of that trust, that family trust now, are the trustees. Okay, they're also responsible for following the trust directions. So some of the language that you might see in a trust is the health, maintenance, education, and support of the beneficiaries. So these are kind of the four magic words. Well, if you think about that, though, that could encompass a lot of things. If I were a beneficiary of Marsha's trust, I might feel that I needed to go to a rodeo for my education or something like that. And so, so I think it's very important that the document really spells out, and we'll get into this a little bit later, but as you can see, those are really broad words. So you need to make sure when you're setting up your trust that you define what you consider education to be and what education you'd like these assets to be used for. Is that informal education? Is it a degree program or a certificate program? Do they need to finish the program? Is it only traditional universities or colleges? Some people like to specify which college people will attend. So you really need to make sure that the trustee understands your wishes and how you would like those assets to be spent.
I'm sure most people would say that on that education that they have to go to Montana State University. Wouldn't you agree?
Yes. It's the only time that would be acceptable.
Yeah.
Sorry, just a side note. So it's really typical. One thing that we're going to talk about are typical revocable trusts. So in this case, the settlers and the trustees are the same people. So these are either the parents or the grandparents, and you would set this up while you are alive, and you're going to put your assets into that and then use that money to support yourself. So the trustees for this, potential trustees for a revocable trust could be your adult children, your adult grandchildren, maybe you have a trusted friend. I know my grandma did that. She chose a trusted friend that was located near her. Maybe it's a charity or a nonprofit, or a corporate trustee, which might be a bank or a trust company. One thing to think about is the cost of having a corporate trustee. So you also want to think about, we've talked about this before, as far as naming guardians for minor children, and the same would be true with the trustees. So this would, you want a successor trustee, and that's someone who's going to take over those duties. If for some reason the initial person that you named becomes deceased, becomes incapacitated, fails to act, or maybe they resign and aren't able to fulfill those duties. So again, those people could be the same, an adult child or an adult grandchild, a trusted friend, a charity or nonprofit, or again, a bank or a trust company. So beneficiaries are people who are going to receive the income and assets from a trust. They can receive that income, maybe it's a monthly disbursement, maybe it's a quarterly disbursement, maybe it's an annual disbursement. And they're also going to receive assets upon the death of the trustor or trustees, or at some point in the future. So you could name an age. Maybe it's, you feel age 30 is the appropriate age, or age 40 or 45. And Marsha shared a story about somebody who was 65, which would be a kind of a cool gift for retirement as well. So whatever you feel, however you feel like you want to distribute those funds. So the trust agreement, this is the written document that I referenced earlier that's containing the instructions to the trustee. So this is really where you're going to capture what the essence is, what you see as education, how you want those assets to be spent. So it's going to capture your intentions. This could be in your will, but most people make a separate document that really clearly spells out their intentions. And then most people have a will in addition to it setting up a trust, and that's kind of the just in case. So a pour over, it's just a provision in case you've forgotten any assets to place into the trust, or maybe you've acquired them later or haven't gotten the paperwork done or whatever that is. So you just want to make sure that you've covered all of your bases. So it's a good idea to go ahead and have a will to cover any of those assets that might not be included. So what does it cost? And I think that this is a question we don't answer really often, because it's such a broad, it's hard to, it varies by your situation, by how complex it is, by how ready you are, and all of those things. But I do feel like it's important to have some sort of an idea. And I know it was something that I worried about when I was first setting up my will, was, gosh, I don't even know if how much should I budget to walk into the attorney's office to get this done? So just so you have some ballpark figures, the cost could be between $2,000 and $8,000 for a married couple with children, and kind of between $1,500 to $5,000 for a single person with children. And that'll just give you a rough ballpark. There are some things that you should do before you go to the attorney's office, and some decisions that you want to start thinking about so you can make. So one is, how is the trust money to be spent? What is important to you in that? Who should be the trustee? Who do you trust to name to fill that position? And at what age should the assets pass to the children? It's easy to look back and see what age, but you're looking forward. So at what age do you want those assets to be there for them? And the more that you plan and think about those things, the more smoothly it's going to go with your meeting. So our tip from the Sugar Bowl is we want you to go ahead and know that you can read the MSU Extension Mock Guide for additional information on revocable living trusts. So you can download that and study that more closely if you'd like to. And those are all listed on the website. And don't get bowled over with a trust until you learn more. So we have another trivia question for you. So what is the dollar amount that what is the federal estate tax exemption for 2022? So what amount is the federal estate tax exemption for 2022? So if you'd go ahead and just put your answer in the chat, and then hopefully you're one of the first ones and one of the lucky people to receive one of these beautiful wildflower cards.
Okay, while people are doing that, I'll just tell you the flower that's on your right is called a gentian. And one time I was in Yellowstone Park and my husband took a photograph with me with one of those because it was as tall as I was, which, you know, 5'2" isn't really tall, but that was a big, big plant. And I haven't seen one that tall since.
Oh, that's cool. So Marsha, would you describe to us how a testamentary trust works?
Okay, well, we know that revocable means we have it while we're alive. As a matter of fact, I've been using the term revocable living trust, and I had one of my colleagues who were writing some information, and he informed me, Marsha, if you look at the code, that word living is not there at all. So you should refer to it as revocable trust. So that's what I've been trying to do. I can learn too. And the testamentary trust is one that you write in your will. And so therefore, it doesn't become effective until you pass away. So the thing is, with the testamentary trust, you do not have to retitle all the assets that you've got. What you've got to think about is how do you get them into the trust? And we'll take a look at that. I'm going to use Richardson's geranium to introduce Granny Richardson. And Granny Richardson is a nice lady who took on the raising of 5 grandchildren. If you can imagine, my goodness. Well, she has a goal in her estate planning, and that is she wants to treat all of her grandchildren equally. You know, grandparents and parents want to do that. There's this thing about equal. So what she did was set up some mutual funds and some CDs, and she'd been to one of my estate planning programs, so she decided she's going to put a transfer on death registration on the mutual funds and a payable on death on the certificates of deposit. So look at the assets that Granny has here. Is she treating her grands equally? How about that, Mandie? What's the problem there?
Well, I want to be Tim.
You want to be Tim? Yeah, I would too, because he's the one that's going to receive the most. So Granny is a little disappointed in these tools that I gave her, and she said, how can I treat them equally? Well, I'm not an attorney, you know, so I can't give legal advice, but I am an extension specialist, so therefore I can provide educational information. And I said, Granny, there's different ways to achieve your goal. And she's just still concerned about this uneven distribution. So I said, think about the possibility of a testamentary trust, because you could put a provision in your will that you want to establish this, and then you want all your assets to go into that trust, and then you can treat the grandchildren equally. So that's what she's going to do. But she said, I'm going to use PODs, TODs, and the T with the double D, and that's her home. So let's take a look at what she did. She said, well, I've got some life insurance, and instead of listing all the grandkids, what I'm going to do is list the testamentary trust. She's going to do the same with the POD on her banking accounts or the account she has at a credit union. her securities, stocks, bonds, mutual funds. Well, she could put a transfer on death registration of those, and those go into the testamentary trust. And then, she said she was going to use that Todd to get her home and put that into the trust. And then if she happened to have any retirement plans that would go on to survivors, that would go in there as well. So what Granny has done is she also took Mandie's advice here to have a written will with some pour over provisions that in case there's anything that she forgot to use one of those beneficiary designations on, that would pour over into the testamentary trust that she has. So she's then got some choices, and I call this one Plan A, because what she could do is have one education fund for all the grandkids. And then upon the graduation of the last one, then it would be distributed to the balance that's there would be distributed to all the grandchildren equally. So in this case, Plan A means that at the end, everybody would get 1/5 of the balance that would happen to be left, if any, in that account, because we all hear how education keeps going higher and higher. Now, another thing that Granny could do is do Plan B, and she could have an education fund for each of the children. Okay, so she could establish that, and then she could say once they're through with their education, if there's any balance that's left, that could go into her favorite charity, which in Granny's case is the Montana 4-H Foundation, because she used to be a 4-H project leader. And then she's also fond of the Montana Community Foundation because they have great programs all over the state, and there's local programs as well. So the benefit here of having this testamentary trust is she does not have to keep changing beneficiaries, trying to keep everything even. She can make the bequests equally to her children through the testamentary, or grandchildren through the trust. And then the other thing is that these beneficiaries' creditors do not have any right to attack or attach a claim to the trust, because the trust is the owner, the children aren't. But once the grandchildren would have that money come into them, then creditors could go after anything if the kid's done something stupid, and has high creditor bills. So
Marsha?
Granny Richardson does have a tip for us, and she says a testamentary trust could be a useful tool for treating your children and grandchildren equally.
Marsha, we have a question.
Okay.
So, if you put land in the testamentary trust, do you get a stepped up basis?
Okay. The question is about the step up in basis. And I think we probably have some folks out there that don't know what that means. So just real quickly, keep in mind that when all of us die, sad but true, anything that we own, whether it be a house, land, equipment, anything gets a stepped up value. So that means, let's say that you bought a farm back in the 50s and it was $50,000. And when you die, it's worth $6 million. The value is stepped up to the $6 million. Now that's important because if that person decides to sell it at $6 million, there's no capital gain. So the step up in basis, it doesn't matter if you get the property through a will, through a Todd, or the person died without a will and you inherited the property under the laws of intestate succession. You still get the stepped up basis. Okay, hope that answered that question. If not, ask for more. Oh, we got another trivia question. What is the dollar amount of the federal gift tax exemption? Okay, so let's just say we've got a great big old ranch out there and we want to give it away. How much would be exempt from the federal gift tax? Okay, need a little water here. Oh, Mandie, you're on next. Why don't you use my infamous Explorer's Gentian to describe some other uses that we could have with a testamentary trust?
Marsha, I have a quick question for you. Wasn't that question already asked?
No, I think we already had the estate tax and not the gift. But if I screwed up, put it in there again, because maybe you had it wrong the first time. Okay. And we got Mandie, not Randy. Mandie, you're on. Mandie, you're on mute.
Oh, thanks.
I should have got my sign.
That's all right. I would have. All right, so we're going to explore the use of a testamentary trust for a child with special needs. And there's actually a group of attorneys who work together to deal with these trusts, and that's the Special Needs Alliance. And they're a great resource. So how can we use a testamentary trust to protect a financially incompetent heir? So that could be an heir that maybe really just can't manage their money, possibly is suffering with some addiction problems, or maybe has chosen a lifestyle that puts their financial stability at risk. So this is a way to protect the assets and provide some support to that heir without them losing all of their assets of the trust. So we want to use, another consideration is maybe an incapacitated spouse. So you may have a spouse with Alzheimer's disease or another form of dementia, a spouse who's suffered from a stroke or a brain injury from an accident. And this is a way to provide for their care, and maybe their care needs that aren't covered by insurance or other funds. So this would be an extra way to make sure that you cared for those heirs also. So let's look at our Explorer family from 2010. So in 2010, mom passed away and dad has Alzheimer's, and there's one living son, okay? And so mom didn't plan. She didn't make a plan. So we have a poll question here. Mom dies, and what fraction, if any, does the surviving son receive?
And don't forget to hit submit.
Yeah, thank you, Marsha. Hit submit. Don't just answer, or else we won't see your answers. So we want to know what fraction of this estate is going to go to the son.
Because mom didn't have a will, she didn't do any of those techniques. So we've got, there's your answers there. See those, Mandie?
Okay. Yep. So we have most of our answers said 1/3. Excellent. So I'm glad that we asked this question. So what will actually happen is the son will receive nothing, and the dad will inherit everything, which is probably where we want the care to go. However, he's not in a position to make those decisions. So now the son is going to have to go to court to name guardianship for the dad and conservatorship for the dad, which is a really it's an added difficult process and an added stress for the family. So they have to go to court and go through all of those steps to make sure that they can protect those assets for dad.
And
So
you never know with the person, sorry, Mandie, that has Alzheimer's. If there's someone that is at a stage of being very angry, that's difficult in a court situation. The dad doesn't even want to go, or we have a situation where the dad just he can't communicate anymore. And it's really tough to have a family member in court like that. And you've just got to feel really bad that you've got to go through that procedure. So I admire anyone that says, we've got to take the bull by the horns here and get some planning done when we have an Alzheimer's diagnosis in the family.
Excellent. Thank you for sharing that, Marsha. All right, so here's an alternative. Mom could set up a testamentary trust for dad and name her son as the trustee. So then her son is, or their son is going to be in charge of taking care of dad, protecting the assets, and making sure all of dad's needs are met. So this would just be an easy way to do that. So our tip from our Explorer's Gentian is a testamentary trust could avoid a guardianship or conservatorship procedure and make things a lot easier. So Marsha, I'm going to challenge you to use a wood lily to share information about the distribution and standards for trusts.
Aha, I got you, Mandie, because I have thought about this and I'm going to use the wood lily because I would explore with you these distribution standards. And in the information about trusts, one of the things they say is you can have a discretionary distribution or you can have a mandatory. And so let's take a look at what those two mean. Because if it's discretionary, you're leaving everything up to the trustee judgment. And there's some documents out there that have exactly what Mandie said earlier: health, education, maintenance, and support. Oh my goodness, that is broad. And it means you really have to trust your trustee to know kind of what you want. And that's why the trustee and you should have a discussion to define your education requirements. Is it going to Montana State, or is it going to a beauty school? Learn how to cut hair, learn how to do welding. And maybe you just trust the trustee to make that decision for you. But I'm going to make all of you a trustee today. And I want to introduce Chris, because what Chris would like to do is take a trip in the summer because he wants to explore, notice the explore, Europe. So the trip would be very educational, says Chris. So here you are, the trustee. And would you provide the funds from the trust to Chris so he could explore Europe? Okay, because you think, well, he says it's going to be very educational, and maybe you agree with that. But you let us know. You can only answer yes or no. You don't get to put in there, he's got to pay half of it or something like that. Yes or no. Okay, let's see. Got to get the right thing here. So we've got Mandie, 35% of the people are saying no, and we only have 6% that said yes. And I chuckle at this because what I find when I ask a similar question when I was able to do live meetings is that it depended on the part of the state I was in. If I was in Bozeman, they go, yes. If I was in Missoula, they go, yes. But if I was in Ekalaka, no offense against Ekalaka folks, but they would say no. So it depends on the perspective. And I share that because if you are a trustee and it's up to the trustee judgment, you could see that there could be some differences of opinion there. Oops. Okay, so mandatory standard. The mandatory standard would be dictated by the trust document. So you might say you're going to distribute it at a predetermined age. You know, those examples Mandie was giving, 25, 30, 35, or even the lady at my meeting, 65. Okay. And there's also age distributions of they would receive those at the dates we talked about, or even intervals. You could say part of it goes at age 25, part of it at 30, and part of it at 35. Okay. I have a question about you. What's your opinion? What do you think would be the best age to distribute the assets to someone in a trust? I'm sure you've heard the term trust brats. Well, you don't want to have a trust brat, right? So what do you think is a good age to get that distribution done? course, we had somebody in the chat room when I asked this in another program and put any age would be good. So they're not saying a specific age. Okay, let's see what we've got here. Well, we've got 35% that say 26 to 30 years. And we've got 24% that said 37 to 40. And so we've got some differences, but none of them are giving it 22 to 25. And I think that is a reflection, you know, there is experience that goes with understanding of how to manage your money and other resources. Now, there are some who would explore a life stage, and they would then distribute the funds upon a graduation from college, maybe when they got married, or maybe at the birth of the first child. We have grandparents that like to influence, or parents do that. And regardless, your attorney is going to tell you, you would use, of course, percentages. In the old days, you know, money was money, and you tended to say, I'm going to leave 10,000 here, 10,000 there. And now we do percentages because we don't know how much we're going to have left. And that could be the same situation with the trust. So you've got the opportunity, since values change over time. So you would explore, maybe we leave 55% to the Montana 4-H Foundation and 45% to the MSU Alumni Association for the benefit of MSU Extension. Thank you very much. All right. How much does it cost? You know, as Mandie said, you like to get an idea of how much does it cost to do these types of management for the trust, or even establish one. So to establish one, I saw figures from 1,600 to 3,000. And, you know, it could be more, it could be less, just depending on what you include in that. And then I also found that if you're going to have a corporate trustee, the cost would depend on complexity of it. I had one institution that says, we do not do farm, ranch, or downtown businesses. If we were asked to do that, we would be quite clear. We will convert those assets to money. We know what to do with money. We don't want to get into the situation of renting apartments and things like that. And then I asked about a dollar amount. And this particular institution says, you know, if you've only got 300,000, you know, we would recommend that you use a relative. It's the cost of managing that. We need more money so that we have less percentages, and it makes more sense. You don't want to have a trust with only 300,000 in it and lose some every year because of the fees. So I thought that was a good, honest response to that. So a testamentary trust would be used to protect our assets for minor children, incapacitated folks, you know, with dementia, and things like that. So I think, Mandie, we're probably about out of time, and we do want to leave time for our great guests that we have today. You're on mute.
I'm muted. My building's really loud, so I put myself on mute so you guys don't have to hear the wind. Anyway, I apologize. So our time is slipping away, and we do want to make sure that we leave time for your questions. So we hope that we have steered you to consider the benefits of a revocable trust for the protection of children and grandchildren. And we also hope that we have steered you to consider the benefits of a testamentary trust as a protection for your children and grandchildren. So if you don't have a memory like this elephant's head, which is this beautiful little flower, we also want you to know that you can look up the Mont Guides at montana.edu/estate planning, and you can click on the estate planning publications and download resources that can help you review what we've talked about today. You can also go into your extension office and get those from any of your extension offices can download those for you, those mock guides or fact sheets. So let's go over our trivia answers. So what is the amount that you can give annually that is exempt from the federal gift tax? And that is $16,000. So hopefully somebody out there, some lucky winner, was able to get that right.
And I'll throw in there, Mandie, the reason I asked that one is that is an increase. For years and years, it's been 15,000. And the idea was it would be increased in $1,000 increments when inflation made it raise high enough. So that's why this year we finally reached the 16,000.
All right, thank you. Yeah, great. Okay, so our next trivia was what amount is the federal estate tax exemption for 2022? And that is $12.06 million.
Yeah,
And
it's even kind of hard to say that, isn't it?
Yeah, I had to think about it.
nobody
I don't
got
think
that
we need to
right.
worry about it since we work for Extension MSU. But I might throw out there that it is double that for a married couple. So a married couple can have 24,120,000. So really, for most of us, we don't have to worry about the federal estate tax. We need to do our planning, make sure that we get the property to the children and the grandchildren and our friends, whatever it is we want.
Okay, and our
Marsha and
final one.
Mandie, nobody got this right.
Oh, okay, shoot. And the amount for the federal gift tax exemption for 2022 is the same.
Yeah, it doesn't mean though, Mandie, that you get two of them. You get one for estates and one for gifting. They're unified. That's what the law did. And for a while, it looked like that was going away. And it still may in 2025, but we'll wait and see. But in the meantime, it increases by the rate of inflation. So 12.06.
Excellent. All right. So make sure that you set aside time to join us next week for our next webinar, and that is saving more for your children and grandchildren, how avoiding probate on your assets at death. So that is February 24th. And so let's go ahead and jump in with our special guests. So Kari and Heidi.
Yeah, if you got some cameras, turn them on so we can see you.
Hi,
Okay, we got Heidi waving. Very good.
Awesome. So I'm going to just
We got
start
Kari
off with
there.
a couple questions. Our first question, and Kari, you can go first if you'd like, is can you tell us your story behind your estate planning?
Sure. So like they mentioned, I'm an MSU extension agent. And so probably for about the past, I don't know, 6-7 years, we've been involved in hosting Montana's Next Generation Conference, which has focused on succession planning for the farm and ranch. And so last year, Marsha had given a great presentation. And so we were having a little breakout room. And so Marsha had asked me, Kari, do you have your will done? Because she knew that we'd had a daughter that past year. And I said, no. And I felt a little hypocritical to be promoting this, but not have one done. So that was a good little push. And so my husband and I made it our goal last year to get that done. And so I called up the attorney in February and he kind of said, this is the process. This is a quote. Come in and visit. You know, if you decide you want to go with us, great. If not, you know, we won't charge you anything for initial conversation. They sent us some forms, and so my husband and I talked that over, filled that out, sent those back. We had a little video meeting. They did everything else. And then at that point went back in later and signed. And so from that, they gave us a really nice binder that has our wills in it and healthcare documents and power of attorney and all that kind of stuff. So
That's awesome, Kari.
Do you
And-
feel comfortable sharing a ballpark figure on what the cost was?
Yeah. So that's when Mandie had mentioned costs earlier. I thought, well, I'll share mine. And just as a point of reference, I live in Cut Bank. We didn't use an attorney in Cut Bank, but used one locally, so northern Montana. They had originally quoted us $1,000, which I thought seemed fair. We also have a ranch, and so we had some other assets to, deal with besides just maybe normal things. And but as it turned out, we got 50% off because the attorney felt bad that it took as long as it did. So he said, I'm going to give you 50% off. So we only had to spend $500. So I thought that was a good deal.
Oh, yes, you did get a good deal. That is fabulous. Yeah. And honorable thing for the attorney to do. I had run into a couple of situations where the attorney didn't get to it. In this case, it was an older couple. And lo and behold, the wife died before they got it all done. And I thought that was very unfortunate.
And I will say this past fall, my husband was diagnosed with cancer and everything has turned out fine and things look positive. But I will say, had we waited until then to be like, oh my gosh, we need to get this done in the next 4 days before you go into surgery, there's not time for that. You have to have it done. And it's so nice when you are in that situation and they ask, do you have a health care, this, and that? And it's like, yeah, actually, we do have those documents done. So.
What kind of advice would you offer others? You said it was kind of me that kind of did the prodding. Um, how could you get other young folks interested? Because, at your age, it's not something we think about.
Yeah, I guess I would say the process was fairly simple and straightforward. They gave us forms to talk through. And so it's one of those things, you just have to get it done, make it a priority. I think we always say, oh, I don't have time for XYZ, but you make time for whatever's important to you. So we'd also made some goals last year. And so that was one of the things that we put on our goals for the year was to get that done. And so, I would say it's fairly simple to do and just get it done.
How about your discussion of guardianship and conservatorship? Do you feel free to share the process that you guys use for that?
Yeah. So my husband's from Nebraska and that's where all of his family is. And so we pretty much thought, well, obviously we're living in Montana. Let's choose someone locally. So in the event that, if we both died and she had to be under the care of someone else, we would prefer that she stay in her own community where she knows people and would be around at least one set of grandparents and aunt and uncle and that sort of thing, versus all of a sudden, hey, you're moving 1,000 miles away to be with family that you don't know. So that was our discussion there. And then also my parents are early 70s. So, we would probably adjust things maybe in 5 or 10 years down the road, but for now had said, maybe they don't actually become guardians, but we trust that they could make a good decision if they had to of where to go with our kids. So that was kind of our discussion there. And then also we have some of our friends lined up and just, who has similar values and who would be maybe have kids in a similar stage of life where it wouldn't be a huge change for our daughter. So.
That's great. Mandie, do you have some other questions for Kari?
Yeah, I do. I was wondering if you would share with us your favorite estate planning tool.
I would say a good attorney. Just listening to today's presentation, I'm like, well, did we do that? And obviously there's a lot to this. And so I think just having a good attorney who you can trust is well worth it because they deal with this every day. And so that would be my favorite tool.
Mm-hmm.
Awesome. And then is there anything else that you'd like to share?
I guess I would just say two things. One, be very clear in your conversations with your spouse or your partner, we had kind of talked about things, but in my mind, we hadn't necessarily come to a decision. We have these friends over for dinner, and my husband goes like, "Hey, do you want to be guardian of our daughter if we die?" And I'm like, I didn't think we were to that stage that we had agreed upon that, but that's just our own communication there. So I would say, know who you're communicating with and be very clear before somebody goes and asks someone, because then it was a little bit awkward. The other thing I would just say is I think the process was very good because it makes you think about your values, and even in a will, who do you want to leave money to? And then it kind of gave me the thought too of like, well, why do we have to wait until we die to have an impact? If we want to bless these organizations now, then let's just budget for it and let's have some impact now. Because it's kind of exciting when you think about like, oh, this could go here and we could, donate to this and this. And it's like, well, let's just do that now too. So I think the process is good because it makes you think. And again, I'd say just get started. Even if it's just making a phone call asking, what do you charge? Just get started doing at least one thing. So.
Awesome. That's excellent advice. Thank you for sharing. And if anything pops up, please jump back in.
Good.
So
Okay.
Heidi, oh, go ahead. Go ahead, Marsha.
I was just going to say, let's roll over here to Heidi. And Heidi Lester is with us today. And she is involved with the Kinship Caregiver Program in Montana. And this is one of grandparents taking care of grandchildren. So tell us a little bit about that program, Heidi.
You bet. Thank you so much, both to Marsha and Mandie and Kari, everybody. I really appreciate you having me come to the table here. If there's one thing I love to do, it's talk. And if it's the second thing, it's talk about what I do. I'm pretty passionate. So our program isn't new to Montana. Many of you may have heard of us as grandparents raising grandchildren for several years. At the helm was one of my favorite people, which was Dr. Sandy Bailey. When she retired, it was at the same time where, this is 2018, the feds released a whole bunch of money for the Family First Services Prevention Act. I always get those letters wrong. What it did is it gave states money to either develop or enhance their current Kinship Navigator. That term was new to our state. So a navigator is just someone like a caseworker who would work hand in hand with a caregiver. Who are kinship caregivers? So these are individuals, anybody who raises another relative's child, whether they're related or if it's fictive kin. The program seeks to support all types of caregivers. We build by helping them build safety, stability, permanency, well-being. We also work with community capacity, building that. And right now we have a big focus on trauma-informed care and trauma-informed parenting practices and all those kinds of things. We have an estimate now of over 9,000 children in Montana are being currently cared for by someone other than their own biological parents. And
9,000?
9,000, and almost 2,000 of those are involved with CPS. There's two systems. You have a formal system where an event has happened, a child's been removed and placed with a caregiver, or you have the informal, which happened to myself. My brother struggled with addiction issues for years, and we had agreed to watch his children for a weekend, and he was gone for 8 months. So he just disappeared. So I end up caring for his two children. So we seek to support both groups. There is support, financial, legal, medical, education support for both groups. We just need to have conversations about that. We have outreach. We provide information and referral. We have support groups. And in fact, I was being a nosy noodle going through the attendees, and I know I have at least one support group facilitator on this webinar. So I was really excited to see that. We have 8 support groups across the state right now, a mixture of meeting online and in person. They are run by people like myself, a navigator. We have extension agents that do that, and then peer caregivers, because we know that lived experience and talking back and forth is the best thing. So this is perfect on what the other Kari here, Lewis, was saying, is if for some reason you suddenly find yourself caring for another relative's child as a guardian or something, we are a step to help you find a way to best provide care for that child. That's my elevator speech.
Yeah, pardon me for just doing the wow thing, because I can remember that figure of 6,000 And when
Mhm.
I would mention that to somebody, they would think that that was awfully high. And now I got to change my number in the head and say, you know, we do have a lot of grandparents out there then that could benefit from
Yes.
doing some estate planning because they are caring for these kids. And oh my goodness, if grandma and grandpa go, well, what's going to happen?
Yes,
And
exactly.
so that would be very good because they could, as parents, nominate a conservator and a guardian through the will, and that would be great.
Yes.
Kari, are there any questions that our participants have for Heidi this morning?
There is
And I
not,
see,
Marsha.
okay, I see Heidi put a link in the chat room there. That
That's
is
our
great.
website. Yeah. So if anybody
That's
has
the website.
you can click on that, contact me, call me, text me, email me, you know, send up a flare. I don't know if you have any questions. I love to talk about what I do and I'd love to get you help.
Okay. Well, that's a very positive note to end on. And so I think what we'll do is close and get to the questions that people have. So Heidi, we thank you very much for joining us. And Kari, thank you as well. And also thank your husband because it was a real team effort for you guys to get your estate planning done. And I'm still just so proud that you got it done. And you can be the example for our other extension agents that may need to do some of that planning as well. So thank you for joining us. Very good. And we'll open it up. Do we have any questions, Kari?
Yes, one person asked who sets up and manages the counts when the kids get older?
Okay, what accounts are we talking about? I guess I need a clarification on that because, you know, once a kid reaches age 18, if they've inherited any property, they get it. Now, if we had one of those custodial accounts that was established for the kid, the child does not receive it until age 21. But once they're past 21, even if they're not very financially competent, and that's the word I like to use, or incompetent, as the case may be, there's nobody there to help them. And that's where if you know your children or grandchildren well enough, that you would give a thought to a trust, because then the trustee could assist with helping that person learn better financial decision making through time. And then the trustee, if you left it up to the trustee to decide when to make the distribution, you know, that could be at age 30 or at a point that your trustee goes, yep, the kids learned a lot. And now, especially if we had a large inheritance, you know, I mentioned maybe not this group, but there was a kid that inherited at age 18 a ranch. And he thought he knew more than his uncles and everybody else. And in 2 years, he had lost it. He could not handle the decisions that he needed to be handling because he thought he was so smart. Other questions?
We just have one more question. Is it recommended to make graduated payouts as the kids age? Like, for example, 100K, but only tap into 30K at age 21, 30K at age 25, and the remainder at age 30, or do something like that?
Yeah, there are people that do that approach. You know, they don't want to just turn over that much money to an individual at one time. And so, you know, it's your judgment. You're going to know your kid, your grandchild, or your child better than anybody else. You know, if you're a realistic parent. And I had one woman or a mother share with me that, oh, she was just fine with leaving a certain amount to her daughter because her daughter's always been responsible. She says, my daughter probably has the first dollar she ever earned, but her son, she just wasn't comfortable. And so what she did is leave the son's share in a trust, and it was managed then by the attorney's sister. And I thought, oh boy, that could be a little interesting. But even the kid told his mom, you know, because mom talked about it and said, this is what we're going to do. He said, you know, I know me. If I had that much money, I'd blow it. So he was glad, and, stay tuned for the end of the story to see if it was still amicable towards the end. But that was where your kids, and you've got to make some of those tough decisions that some can manage and some that can't. And are there ways that you could help that child by giving a little bit at a time rather than all at once? Okay, Kari, you said that was the last question.
Yes, that's the last question, Marsha.
Okay, Mandie, you want to wrap her up today?
All right. Well, thank you everyone for joining us. We hope that we have inspired you or our panelists have inspired you to take some action and move forward and explore the topics that we talked about today, or maybe the topics that we've covered earlier to continue with your estate planning. We thank you for your time, and we hope to see you again next week. And again, if you have questions that didn't get answered, please feel free to reach out to any of us or to Marsha, especially to see if we can make sure we get those answered. So thank you to everyone who joined us. Thank you to our panelists. Thank you to Kari Hayes for managing our WebEx, and we'll see you next week.
Okay, bye-bye, Mandie. See you next week. And bye, everybody.